Good evening, everyone. Welcome once again to Legal Hour with Connaughts. As you know, we take live questions from you, so please feel free to write any questions on our live Facebook feed. Uh, in this program, we discuss different immigration issues, we discuss any recent changes in the immigration law, and most importantly, we answer your questions live. So please feel free to start writing your questions like you always do. As usual, we have Shahryar Khan, our head of immigration, with us today to answer all our questions. How are you, Shahryar?
Very good, thank you. Good evening, everyone.
Today, we've decided to address few issues. We have some new immigration changes coming in from 24th of July, especially for EEA nationals. We also have a couple of interesting case laws.
That's correct. I think we're just experiencing some technical difficulties, just sorting something out. So please bear with us for a minute.
So all these immigration changes and new case laws, we will be, Shahryar will be obviously giving his views on those. Um, we also decided to go through re-entry ban policies today, which is very important. We have received a lot of questions from our existing clients who want to know in what scenario and situations re-entry bans apply. So these are the questions we will be addressing today. So starting from new immigration changes coming in from 24th of July for EEA nationals. Sharia?
I mean, as Wes said, we've been in recent times been talking a lot about the human rights rules and paragraph 322.5, the 7-year rule. But we've seen ever since Brexit and or otherwise, there's a lot of interest in the EA law, what it entails, and also separately from that, for the last week at least, we've seen there's a lot of interest on re-entry bans. So I wanted to start today's program by talking about the re-entry bans. There was a very interesting change which I suppose missed the radar for a lot of practitioners as well as those immigrants affected by re-entry bans. That change was brought in around April 2017. So basically the old position, the traditional position, the position which has been in place for a very long time was that if you overstayed by less than 90 days, then the general rule was that there's no re-entry ban, which would basically mean for some reason whatsoever, let's say you make a student visa application and that application has been refused, a lot of students in particular would take some time before they would leave the country. They wouldn't appreciate the seriousness of the fact that they are overstaying. As opposed to that, we've seen usually always would have experienced that when migrants were here on tier 2 or tier 1 visas, those migrants perhaps, whether it's age, whether it's profession, they were taking immigration concerns quite seriously. So what would happen in the long course would be those students who overstayed, when they would go on to apply for visas to come back to the country on good jobs, professional jobs, they would not be permitted to come back within at least 1 year because they've overstayed by more than 90 days. Now, that used to be the general advice that would be given to students and or otherwise migrants that would be affected by this rule. That rule changed in April 2017. So now what everybody needs to bear in mind is that the re-entry ban is triggered after 30 days. I've just been told by my technical team to speak louder, so apologies if you've not been hearing me before that. I think I'll move ahead a bit as well. So basically, as things stand now, the re-entry ban is triggered, and if anybody overstays for more than 30 days after their visa expires or after their 3C leave expires, after their appeal has been finished, then there's an automatic re-entry ban of 1 year. So it's very important now to take this into consideration because we are getting a lot of cases with genuine students who want to come back to do their PhDs or take up jobs. Even migrants on a tier 1 visa, which we are assisting with recently, they've overstayed thinking that the rule still is that you can stay here for up to 90 days. That system's changed. So please bear in mind that you cannot overstay or stay in this country for longer than 30 days. So just to recap, if you overstay for less than 30 days and then you leave on your own expense, which basically means you buy your ticket, the Secretary of State does not enforce the removal, then there is no re-entry ban. You can leave the country and come back, provided you meet the rest of the immigration requirements for the rule. The 1-year ban is triggered if you have, well, the obvious one is that if you entered illegally, but it also applies if you overstayed, which we've been just talking about, It also applies if you've breached an immigration condition, which basically means if you're on a visa which prohibits you from working, is a good example, and you've been caught working, then there is a 1 year ban again if you've left the UK voluntarily. So that's something to bear in mind as well. We sometimes advise applicants who are in immigration detention or otherwise facing difficulties, and they try to stay on in the country as long as they can, and eventually they leave and then they look for options to come back. And sometimes what they say is that what's the harm? Why shouldn't we let the Home Office pay for our ticket? Why shouldn't we leave through the voluntary return scheme? So although it appears to be attractive at that point, you're getting £500-600 for your ticket. Perhaps they're giving you some money to relocate. But what is important to bear in mind is that there will be then a very serious re-entry ban, which will be much longer than 1 year if the Secretary of State has enforced the removal. In most cases, that is a 2 year ban if the Home Office has removed you forcefully. So let's talk about the 2 year ban. Now, that again, the usual conditions are if you've entered illegally, overstayed, and or breached immigration condition, but you've still left voluntarily within 6 months of being given a removal notice by the Home Office. So the difference in this case is, as opposed to the previous examples, is that the Home Office has actually become aware of the fact that you're in a country, that you don't have a visa, and they've given you a removal notice, which basically tells you that you now need to leave the country, otherwise they're going to enforce a removal. So in that kind of a scenario, you're looking at a 2 year ban. So again, we've encountered various cases where applicants are saying, well, the Home Office haven't still sent us a notice, haven't contacted us. Don't wait for them to contact you. If the long-term intention is to come back, then don't wait for a notice from the Home Office and leave straight away. As soon as you receive the notice, then you're potentially looking at a 2 year ban. Finally, I guess the most serious one, and well, the most serious, of course, is the 10 year one, but the most relevant one is also the 5 year ban. Now, that's one where the Home Office is effectively detained you, encountered you, and then removed a migrant from the country. In that case, then you're looking at, in most cases, a 5 year ban. So those are the re-entry bans. So the important thing in summary to bear in mind is do not overstay by more than 30 days. And do not take into account the fact that if the Secretary of State is enforcing that removal, that it's going to be easy to come back. It's probably a good idea to spend that extra bit of money and leave at your own expense. So those, I think, are the re-entry bans which need to be taken into consideration. Importantly, after April 2017, the law is 30 days and not 90 days.
That's correct. Just to add to what Shiraz has mentioned, also if you are deported from the UK, Secretary of State's expense or removed from the UK, then obviously 10 years ban applies, so you cannot re-enter for the next 10 years. Uh, in addition, if you have used deception, provided any false documents, or any means of deceptions whilst making an entry clearance application, then again you'll be banned from entering the UK for another 10 years. Mm, Just moving on from that, uh, just to clarify, we have discussed implications of 39E, including the new changes that have come in under 39E from 6th of July. These re-entry ban regulations do not contradict 39E. So you still have to make an application within 14 days if you are in the UK, if you want to make sure that your leave continues, long residence leave continues within the UK. So please do not mix these re-entry bans with 39E.
That's correct. So basically, if you've made an application within 14 days from the time your 3C leave or your visas run out, you then do not get affected by the fact that you've overstayed by more than 30 days. Because you made an application within 14 days, that stops the clock. And that would basically mean until there's a decision on that, you're not really overstaying. But as we said in our last program, that is a one-time, one card that you could play. You cannot make repeated applications thinking that you're benefiting from the fact that you made an application within 14 days. You can only make one application within 14 days, not a number of applications within 14 days.
Sure. Before we move on to our next topic, there's a question we have received regarding fiancé visa. I'm assuming it's for entry clearance. Yes, there is a category you can apply for someone to come in as your fiancé with an intention of getting married in the UK. Just to summarize, conditions are exactly the same as a spouse visa, minus marriage certificate. So obviously you're not married, you engage with each other, and you're making an entry clearance application for the other half to come to the UK with an intention of getting married. Every other condition, more or less, is the same as spouse visa application.
Specifically, the financial arrangements apply because some people do not appreciate the fact they think it's not a marriage application, so the 18,600 threshold and or above that does not apply. It does apply. The only difference between a fiancé visa and a spouse visa is that you're not married, but you're coming here to get married. So in practice, that's for people who do not want the marriage ceremony to be conducted abroad and rather that marriage ceremony take place here in the UK. So that's really a difference. There's another category for the person who asked the question that they should possibly look at is the marriage visitor visa. So perhaps what they're trying to do might be better considered by that. So have a look at the marriage visitor visa as well.
Sure, excellent. Another quick question we received is on Surinder Singh case. We were actually going to discuss implications of Surinder Singh anyway. There is a recent Court of Appeal decision on this matter which has extended the Surinder Singh principle to extended family members, which is a very delightful change for those who could not meet income threshold and they are not married couples. They're living together in a genuine continuous relationship. So Syria, recent case.
Yeah, well, I suppose it might be helpful to speak a bit about the Surinder Singh route before we get on to what's happened with it recently. So Surinder Singh route, which has been around for quite some time, is predominantly engaged by Article 21 of the EA regulations. Effectively, what it says is ever since the UK became part of the EU, that what it did in turn was that it created for migrants looking to stay here and to get their family members to join them another immigration, well, I won't call it immigration rule, but an immigration route altogether. So let's say someone is looking to get married to someone. There is the immigration rule, which we just talked about, Appendix FM, where you need to meet the financial requirements, £18,600. But if you're self-employed, then you need to demonstrate it in a different way. If you're employed, it's so on and so forth. Then there's a requirement for self-sufficiency. It's quite complex, as most immigration lawyers or even applicants affected by that would say, that the immigration rules as they stand when you're trying to bring in a family member, it's very complex. And what happened in the Surinder Singh route, what the gentleman decided to do is that he decided to use the EU law to his favor because the EU law is effectively much more easy to understand and it's much more easy to meet the requirements of. So what that requirement basically generally does is that the applicant who essentially is, the sponsor who is a British national, if he moves to a European state, then he is guaranteed a right to return. And when he returns as an EU national, not really as a British national. So what happens then is that the EU regulations come into play and not the immigration, not the local immigration rules. So effectively, British nationals could take benefit of the rights that are guaranteed by EU law, by EEA regulations. And because they're easier to meet, a lot of applicants decide to use that route. Of course, something to bear in mind is not that we're encouraging this, not that Surinder Singh essentially encourages that. There is a fundamental requirement that the move must always be genuine. It should not be conducted to sort of circumvent the British immigration rules. So there's a minimum requirement typically which comes from the case of ONB, which followed on from Surinder Singh, which says that you must have at least spent 3 months. So a lot of practitioners for some reason and even applicants are not aware and they believe that if you just move to, for example, Ireland a couple of weeks back, you could just go ahead and make an application saying that you've now moved here. So the case of ONB does indicate that there should generally be a residence of at least 3 months in the European state before you can take benefit of that to bring your family member into the European state and in due course to the UK. So how it works in practice is that a British national perhaps moves to an EA state, whether it's any EA state, let's take for example to Paris. So he must have then started generally his business or his job in Paris for 3 months. He should be living there, and that means living there from completely. The transfer of life test indicates, or the center of life test indicates, it cannot be a residence which is habitual, which is over weekends. Your life must in all purposes be transferred over to that European state. So that's the Surinder Singh route. That's once you move to that European state, then if there is a family member who's living in a third country, not an EEA state, that he could benefit from that, and if he joins you, you could re-enter the country through the Surinder Singh rule as opposed to the UK immigration rules. What's recently happened, which Wes was talking about, is that uh, the rights of appeal, which were first guaranteed only to family members, are now also guaranteed to people who are considered extended family members because they're not married. So the difference is, although there's been a lot happening in the last few years with rights of appeal for extended family members, there was the case of Sala, which initially said that the regulations, the 2006 regulations, do not consider this as a application under EA regulations, and therefore there should be no right of appeal. In turn, as the case progressed, it was determined that that was wrong, that there should be a right of appeal for applications under the 2006 regulations. Of course, the story is different under 2016 regulations because there are two kinds of EA regulations. So as things stand, the Court of Appeal has recently now held that there should be a right of appeal for extended family members, even in the Surinder Singh route. So if there's a British national who's got a partner who they're not married to, they're considered as extended family members. Those individuals will now get a right of appeal or should get a right of appeal under the Surinder Singh route.
Yes. Well, just to add, there is under ONA versus Netherlands, there's no requirement for your second optional state to be your permanent residence. Place of permanent residence has to be only your habitual resident place. So, in addition, what the judgment states is that your family member, EA family member, has to be given opportunity to challenge that decision properly. It doesn't specify specifically that there has to be a right of appeal on that application, unfortunately, but the implications are very clear that the only other way of challenging that decision, if you are not married to your EEA sponsor, is via judicial review, and which is not a fact-finding process. So only way a fact-finding process can be obtained is can be used is by an in-country right of appeal, where a judge can listen to the parties and decide based on the facts.
Decide on the facts of the case.
Exactly. So it's a very good development in that area, and in addition, a good development for those who are not married couples. So this principle has been extended to them as well. So again, another good addition to the changes as we discussed last week.
Yes, I believe these still are not part of the EA regulations though, so they would be amended again to consider this case as well, the case of Banjo. So this would in turn now mean that there would be amendments to the regulations. They should then hopefully make the amendment that there will be rights of appeal, because judicial review would not be the place to decide on the genuineness of a marriage, the genuineness of a relationship, so on and so forth.
Excellent. We received a question. Questionnaire has asked, what is the chances of 8 years child not born in the UK but has spent 4 years in the UK? So this is the question we've discussed previously as well. If child has spent the cognitive years in the UK but do not fall within the immigration rules under 7 years rule policy, would that child be able to apply?
Well, the simple answer, as far as the rule is concerned, that does require that the child should have spent 7 years in the country. But beyond that, if you have a look at our previous programs as well, what we've said is that it depends on the age that the child comes to the country. So the child's come here at a school-going age of, let's say, 6 or 7, and then as soon as he's entered the country, he started his schooling here and he spent 4 years in the country schooling. There is quite a decent case, and the judge would have to still consider the case not on the 7-year rule, or the Home Office would need to consider this case under Article 8 under human rights, and there should definitely be a merit in such an application, but it depends on a case-to-case basis on how that particular child would be affected, whether there are any medical conditions in play, whether for some reasons that child will not be able to now readjust to the academic system back home. So all of those factors need to be looked at, but it's definitely not a hopeless case just because the child is not 7, and you should see a lawyer and discuss this in more detail.
That's it. Well, again, we're getting a lot of questions on human rights 7 years policy or the human rights cases, even though we decided that we'll specifically deal with the changes coming under EA regulations. I think it's important to answer these questions
I think so as well. I believe.
Yes. We have a specific question regarding a nationality matter. I'll start with that first. Question states that the British citizen obtain nationality other than by descent in the UK. Child is born after nationality is obtained, but child is born outside the UK. So my understanding is the regulation under Nationality Act, Section 21A applies,
Yes.
and child will be a born British citizen. So child will be a British citizen by birth,
Correct.
because at the time of birth, father was a British citizen, obtained nationality, not by descent, but otherwise by descent. So
Just an important point there. I think there's always been some confusion on this one point that the father, the parent, has to be British national, and indefinite leave does not suffice, because some people consider that because as long as they have ILR, it would be the same. So there's no difference if the child is born in the UK. If the parent has ILR, the child is still British. But if the child is born abroad, then as always said under Section 2.1, the father, the parent, the relevant parent has to be British in order for the child to be British by birth. So if the father or the parent, relevant parent, only has indefinite, it's not the same scenario. Then the child is not British by birth.
Excellent. Another question on 3225, your favorite topic. I know you wanted
It's
to.
quite a popular. I wanted to avoid it, but
Yeah, you wanted to address it last week,
Sure.
but unfortunately we didn't have enough time. There is a recent Home Office report, first instance report on that as well, after the investigations into these 3225 cases, especially for Tier 1 general migrants who have applied for under Tier 1 general category. So, your comments on that?
I mean, was there a specific question on 3225?
Question is, visa is refused under 3225. What are the chances? So, very basic question, but I think we can address the issue
Right. I
as a
mean,
whole itself.
it would help in the future if you specify, because 3225 is a broad immigration category. But if the Secretary of State has refused an application saying that the person is not of good character, then we need to look at the offense or the behavior that they are taking into consideration. We are assuming here, as Owen said, that if we're talking about tax discrepancies, then there are a lot of developments in that area. There are now unreported upper tribunal decisions on this point, which are being passed on to the first year tribunal, and they are taking that into consideration. Although they're not persuasive, they still have a force, and judges are looking at that. There's also now, as OS suggested, a first instance report by the Home Office, because a lot of lobbying was done to basically alert the Parliament and other relevant bodies of the Home Office's practice of refusing these applications only on the grounds of tax discrepancy. So what we've seen is that basically they're looking at all of these factors on a case-to-case basis. So just simply because you've amended your taxes, they are now saying we won't simply refuse you straight away. Because of that, we'll look at it on a case-to-case basis as to what was the reason, if there have been amendments, what was the reason that the proper taxes were not paid up in the first place. It does appear clearly that if there's a third party, such as an accountant, who's taking responsibility, then it cannot be said to be the applicant's fault. That's the view that has been taken by most immigration judges. So it really depends on your case. If this is to do with tax discrepancies, what is the reason for the discrepancies, whether there's a third party responsible for those discrepancies, and whether they're giving something in support of that. So all those factors need to be taken into consideration, but things are not as bad as they were some months back.
Excellent. Another question we have is, someone has lived in the UK for 7 years without a visa. I don't know how that person entered the UK. Probably entered with a visa, then overstayed. Now he's married to a British citizen. He has a child, a baby girl. Well, congratulations. I'm assuming child is a British citizen because mother is a British citizen. He's saying which application can he make, and are there any chances of getting a visa within the UK now that he has a child who's a British citizen and a spouse?
Well, certainly. I mean, there would be two kinds of application from the top of my head which this individual could make. One would be a human rights application, and the correct form for that would be an FLRFP application. You could actually, in a recent case that we did as well, you could use the premium service for this if you don't want to be stuck on by making an application and waiting for a decision. We were successful in such a similar case in making an application on the premium service, and the Home Office actually approved the case on the same day, although the applicant did not have a visa for some time because of the fact that he was married to a British national, had a child who was a British national. The Home Office appreciated the fact that this person really and truly cannot be removed from the country. There was no point taking these things into appeal, so they granted the visa straight away. So that would be an application that I would suggest. That would put you on a 10-year route to settlement. You would need to spend 10 years in the country, and then you'll be able to make an application for indefinite leave. Once you are legal in the country, you could also consider making an application on the spouse rules if your wife, meets the requirements, the financial requirements, so on and so forth. There is the possibility in such a case to make an application for a derivative right of residence as well. We would not encourage that because in the long run it does not lead to settlement. So that's the difference between the two kind of applications you can make.
Excellent. Well, that reminds me of another issue we wanted to discuss was the case of Chavez, where um, now we have a recent changes coming up in immigration rules from 24th of July, where this case is now being incorporated into EA regulations,
That's correct.
where the definition of primary care has been slightly amended. Primary care does not really have to be a primary carer of a British citizen, even though you have someone who is caring for citizen. In this case, it could be a child, and primary carer would be mother. As long as father is sharing the care responsibilities, they can still apply under EA regulations on the basis that father, or under immigration rules on the basis that father is one of the carers of the child. So this is one of the categories you can use, as Shayar has mentioned, and it's an important development that is coming into the EA regulations.
I mean, under the EA regulations, in the scenario you mentioned, you're almost guaranteed to get a visa. But the difficulty, of course, in that is that it doesn't lead to settlement. Whereas in a human rights application, there is that danger that the Home Office might refuse your application, but we do not see such an appeal being dismissed with the child is British.
Excellent. Another question we have is on 7 years policy. Child is 8 years in the UK, born in the UK, and they want to make an application under 7 years route. They want to know what type of evidence they would require. Very generic question.
Yeah, well, it's certainly a very strong application. You already meet the requirements of the immigration rule, which means that the child is 7, the child is under 18. What leaves us with is the last limb of this rule, which is to also satisfy the fact that there must be some reasonableness as to why the child cannot go back. So the fact that the child is turned 7 and born in the UK is not the end of the story. You will still need to demonstrate to the Home Office that there would be difficulties in relocating the child back to your country. So in our experience, what we would suggest is to perhaps engage a social worker, a private social worker if you have to, through your solicitors, and or if one is involved for some reason whatsoever. So there should be some evidence from potentially professionals who are involved with the child to say that the child will be affected. It would not be in the best interest of the child. And typically most lawyers would suggest to you that you could consider using an independent social worker. You could also consider using the services of an independent child psychologist. There's also the possibility of commissioning a report which would compare the academic systems of the UK against the country where you're from. So basically those 3 reports, in our opinion, assist the most, but it comes down to cost and comes down to what your particular lawyer would suggest in your particular case.
Okay. Just to summarize, we started with explaining new EA regulations coming into place. We have touched Chavez. There is another change that is coming up, which is bringing self-employment rights in line with worker rights in the EA regulations. So a lot of questions we have received over the last week as to how this will affect anyone who is a self-employed person. So,
Sure. Well, I guess it's self-explanatory that initially there was difficulty between how the EA regulations were looking at those individuals who were self-employed as opposed to individuals who are employed. In our experience, it was always very easy to meet the definition of a worker if you're employed because you're paying national insurance, you're paying PAYE, you would have pay slips and bank statements, and that would be the end of it. The Home Office, for some reason, is always approached EA nationals who are self-employed cautiously, and there would always be difficulty with when there would be gaps in their exercising of treaty rights. So in comparison, for workers who are employed, what the regulations are clear on, what case law is clear on, is that if there are gaps, which in some cases could be even up to 6 months, where you're actually actively looking for a job, that's you can still be classified as a worker. But for self-employed EA nationals, what would happen would be that if there would be no activity, although you're registered as self-employed, but you're not able to demonstrate that there's any activity, then what would happen is that the Home Office would consider that as a period where you're not effectively a worker, you're someone who's exercising their treaty rights. And the change which is now coming in basically means that this would be in line with the rights of employed individuals. So good news for those who are self-employed, which means that there is a long period of inactivity. As long as there's genuine evidence that they were still self-employed, then those gaps, which could, in our opinion, be even up to 6 months, would not really amount to that person not being considered as a worker as far as the regulations are concerned.
We have a question from someone. Uh, from my understanding, she's on a discretionary leave visa. It's been extended 2 times from 2013, so it's under the regulation that came in from 9th of July 2012.
Correct.
So 2.5 years at a time. She wants to know if for the third time she will be granted and which form to use. A very generic question. We can't really comment on whether it will be granted or not. As long as general rule is, as long as the circumstances are the same based on which you were granted previous extensions, there is no reason why you should not be granted any further leave. Application form in this case most likely will be a FLRFP form.
Yeah, it's a FLRFP form for those applicants who've been granted discretionary leave under human rights after 2012. You are considered to be under the new rules, and therefore you're on the 10-year route. And especially because I think she mentions that she's making a third application, would mean that yes, the correct form would be FLRFP. Again, it's a good idea to speak to your lawyer and show them your visa, go through everything again before making this application.
So another question. Questioner says, my visit visa is refused under 3207A. Will the next application be refused automatically? This is something we discussed in the beginning, that if you have used any documents which Home Office thinks are not things that are not genuine, then your application may be refused for another 10 years if it's an entry clearance application.
Correct. So what will it depends on the application you're looking to make really. If your the last application is refused on 327A, is that what the application is?
3207A, so subsection 7A.
Correct. It depends on the application you now make. It's most likely, of course, if you make an application on the points-based rule. Well, again, we don't even have the information as to when you were refused, but typically speaking, most applications are subject to automatic refusals if there's been deception in the past. There are exceptions. There are exceptions, which basically means if you're making a spouse visa application with the EA regulations, an application to join a family member such as a British child, so you need to take that into consideration as well. But the general answer is there will be problems if you've been found to have received the Home Office in the past.
Excellent. Just at the end, I just wanted to add, like we discussed, we have been receiving a lot of inquiries where now Home Office is taking a very strong stance against separating family members. So, for example, if the whole family is living illegally, even though they have young children, Home Office now is taking further steps to separate those families. And in some instances, they're even detaining mothers who are supposed to be the primary carers of the children. I have seen cases previously where fathers are being detained. Now we had a recent case, even as recent as last Friday, where a mother was detained who had a 3 years old. In these cases, obviously it depends on case-to-case basis, but there are policies in place which Home Office has to follow, UKVI has to follow before they can separate family members. So if you have faced or you know someone who has faced these type of situations, please contact us, and obviously depends on case-to-case basis. We will be happy to provide you free legal advice on that and take that matter from there.
Absolutely.
Yeah. Excellent. Thank you very much. This is all the time we had today. If you have any further questions or we could not answer any of your questions, we apologize. You can still email us, text us with your questions, and we'll be happy to come back to us. Thank you very much.
Good to be here.